Okay, let's unpack this.
Let's do it.
Today, we are attempting a truly epic mission, really. We're trying to find the exact common ethical backbone that underpins, well, 14 centuries of global legal history.
It sounds like this huge philosophical quest, doesn't it?
It really does. But our source material, this amazing comparative study of judicial ethics, argues that the most fundamental principle of justice isn't just universal.
No, it's more than that. It's been actively enforced and with immense courage across wildly different cultures and, completely different legal systems.
Yeah, that's the key.
It is. It's an incredible study because it forces us to look past all the surface differences. Sharia law, constitutional law, civil rights law.
Right.
Instead, we get to explore these pivotal, really high-stakes moments when the law simply refused to bend. It refused to bend for status, for race, or for raw power.
Regardless of the consequences.
Exactly. Regardless of the political, the military, or the social fallout.
So we're doing a deep dive into 3 landmark legal events, and they stretch from 7th century Arabia all the way to 20th century America and then over to South Asia.
And the unifying theme, which is the focus of the research we have in front of us, is just perfectly framed.
It is, isn't it? When truth spoke above tribe, color, and power.
That framing is just essential. It really is, because it isolates the three primary vulnerabilities of any legal system.
Okay, what are they?
Well, first, there's the temptation to spare the well-connected, the insiders. Then there's the temptation to discriminate against the perceived other.
The outsider.
The outsider. And finally, and maybe the most dangerous, is the temptation to just acquiesce to state violence, to just go along with it.
So the core question guiding us today is, well, it's monumental. How did this radical principle of equality before law, something we almost take for granted in modern democracies, how did it first emerge?
And not just emerge, but how has it been consistently enforced? And enforced against the highest forms of privilege, whether it's tribal nobility, an entrenched racial hierarchy, or just the overwhelming force of military might.
That's the real test.
And what's so fascinating here is how the source material links these fundamental ethical principles, like adl, which is justice, and musawat, equality,
right,
which were articulated so vividly in the 7th century, and it links them directly to modern constitutional doctrines, things like the 14th Amendment in the United States, or, say, Article 25 in Pakistan.
So we're literally tracing a single, unbroken moral thread.
A single thread, and it's one that really informs our entire understanding of what fairness even means.
And to really understand the weight of that moral thread, I think we have to start where the rule was first established.
We have to.
In an environment that was, frankly, actively hostile to it. So let's jump straight to 7th century Makkah and set the stage for this idea of judicial impartiality against tribalism.
Okay, so when we talk about justice in 7th century Arabia, you have to understand the existing social contract. It's key.
It wasn't a modern state.
Not at all. This was a fiercely tribal society. Legal protection, your rights, everything was conditional on your belonging, on your tribe.
So if you were an outsider,
you had very little protection. There was no overarching state infrastructure guaranteeing rights.
Yeah.
Your worth, your security, your very survival, it was all inextricably linked to the power and the reputation of your clan.
Which is the context that makes this foundational ruling so revolutionary. We're talking about a case against a noblewoman who committed theft.
And she wasn't just any citizen. She was from the powerful Makhzum tribe.
A huge name.
A huge name. So the stakes weren't just about the punishment of one person. This was societal. It was about honor, power, and the stability of the entire social structure.
Absolutely. The traditional view was that punishing a noble was a profound disgrace that stained the entire tribe.
It was a collective shame. So to maintain the hierarchy, to avoid potential blood feuds or instability, the system would almost always look for an alternative.
Like what?
Oh, things like compensation, maybe exile, anything really to spare the noble from public punishment. Judicial leniency was, in effect, a political tool.
A tool to preserve the status quo.
Exactly, to preserve power where it already was.
And the Makhzum tribe, they understood this system perfectly. They knew how the levers of influence work, so they immediately tried to manipulate it.
They did, and they went for the ultimate lever.
They sought intercession through Usama bin Zaid. Now, for anyone listening, you have to understand, Usama was beloved to the Prophet A. He was effectively a member of the closest inner circle. You couldn't get closer.
It was brilliant political maneuvering on their part. Just brilliant. They weren't just asking some random acquaintance to put in a good word.
No.
They were trying to bypass the law entirely through personal affection, through emotional appeal. They were hoping the Prophet T would show mercy because of the woman's high status and, of course, the pleas of a trusted, beloved friend.
So this moment crystallized the ultimate conflict.
Yes. Does the law serve power and affection, or does it serve objective truth?
And when Usama made his plea, the historical accounts, I mean, they give us this incredible visual of the confrontation.
They do.
The prophet she stood, and his face was described as radiant with divine anger.
That phrasing is so powerful.
It is. It wasn't just a legal disagreement. This was a profound ethical confrontation against centuries, literally centuries, of inherited injustice.
His reaction, you can feel, it wasn't just anger at the attempted interference, it was. It was almost a despair at the historical pattern that Usama's request represented.
He saw the bigger picture.
He saw the biggest picture. He saw this not as one isolated incident, but as the failure point of all previous civilizations. So he didn't just deny the plea, he issued a foundational judgment that served as, well, a historical indictment.
And he laid out this chilling historical context of judicial discrimination. He connects the failure of past societies directly to this exact practice. We have the detailed quote.
Let's hear it.
The nations before you were destroyed because they used to spare the noble and punish only the poor.
That statement is foundational.
Yeah.
It just is. It elevates judicial impartiality from, a mere ethical guideline.
A nice idea.
A nice idea to an existential requirement for a stable society.
So if you don't have it, your society will collapse.
That's the argument. It means that judicial corruption, specifically bending the rules for the strong, is not just unfair. It is the mechanism of societal collapse.
Why? What's the logic there?
Well, think about it. It completely erodes the weak's faith in the system. Why would you follow the rules if you know they don't apply to the powerful?
Right. The system is rigged.
It's rigged. And at the same time, it emboldens the powerful to act with total impunity, without any restraint. The whole social contract just dissolves.
That logic is devastatingly simple. If the law is just a weapon, the rich use against the poor, the whole concept of rule of law just evaporates into tyranny.
It does. But the Prophet T. took this principle one step further. He established the ultimate non-negotiable standard of musawat, of equality.
This is the part that just echoes through time.
It is, because he placed the demand of justice above the highest possible personal relationship, his own family.
It's the shocking statement that really immortalized the principle, not just in Arabia, but globally. He declared, "By Allah, if Fatima, the daughter of Muhammad, were to steal, I would cut off her hand."
To really grasp the magnitude of that, you have to understand the cultural and personal context. Fatima was his youngest, his most cherished daughter. By invoking her name, he was establishing an unbreachable legal barrier. He was signaling that there is absolutely no status, not even the status of the ruler's own child, that stands above the application of the law.
So musawat.
It transitioned right then and there from an abstract moral ideal into an enforceable, uncompromising legal precedent.
And the source we're looking at notes that the verdict was a seismic shock across Arabia.
Of course it was.
That detail tells you everything you need to know about how revolutionary this was. It just shattered centuries of tribal hierarchy and judicial flexibility in a single, unbending moment.
And this established the ethical baseline for what was to come. Judicial integrity requires that while your status defines your place in society, it must have zero relevance in the courtroom.
Okay, so that ruling was an ethical command. It was a moral injunction delivered by a prophet. But the question then becomes, how did this principle survive for 1,300 years and transition into codified constitutional law in modern secular states?
That is the perfect pivot, because that's the journey we're on.
Right. So now we move forward 1,300 years. We shift our focus from discrimination based on tribe and lineage to discrimination based on color and race.
And we do it within a modern constitutional republic.
We leave Makkah and we arrive in 20th century America.
And we find ourselves facing the same core ethical dilemma. It's implemented through state bureaucracy now, rather than tribal consensus.
The setting is the deeply ingrained racial segregation that dominated American life. And the specific case, of course, is Brown v. Board of Education in 1954.
Which challenged the practice of forcing children of color into separate schools.
And the legal harm here, it wasn't just about inconvenience. It wasn't just about longer bus rides.
No, not at all. It was the active, state-sponsored destruction of dignity.
That's what the research points out, that these separate schools were inherently unequal, not just in resources, which was often painfully obvious.
I mean, the dilapidated buildings, the secondhand books.
Exactly. But fundamentally, they were unequal in dignity and in hope. Segregation was a legal declaration of inferiority.
And to understand the challenge of Brown, you have to understand the judicial fortress it was trying to breach. The segregationists weren't just making a social argument. They were standing on the shoulders of the Plessy v. Ferguson decision.
From 1896.
From 1896. That had been the law of the land for almost 60 years.
Right. And Plessy established that infamous, separate but equal doctrine. This was the legal framework that gave racism a constitutional veneer.
A veneer, that's a good word for it. It argued that as long as the tangible facilities, the buildings, the books, the buses, were theoretically equal, the separation itself was legally permissible.
Even under the 14th Amendment's guarantee of equal protection.
Which is the great irony. And that's where the legal sophistication of the Brown challenge came in. The NAACP lawyers, figures like Thurgood Marshall, they argue that the entire doctrine of separate but equal was a legal fiction.
How so?
They argued that separation, when it's mandated by the state on the basis of race, inherently creates inequality.
Because it stamps the separated group with a badge of inferiority.
Precisely. It sends a message.
Yeah.
And that message is damaging, regardless of the quality of the resources.
So this shifted the entire legal debate. It moved from tangible resources to intangible psychological harm.
Yes, to the impact on the hearts and minds of children. It was a brilliant strategy. It challenged the moral legitimacy of the state's action itself.
And the political and social pressure on the U.S. Supreme Court at that time, led by Chief Justice Earl Warren, it must have been staggering.
Oh, it was immense. Southern states had publicly vowed massive resistance. The political atmosphere was incredibly volatile. The stakes were nothing less than the future of American society.
And yet, the court delivered a definitive and, crucially, a unanimous decision. That unanimity is such a critical detail, isn't it?
It is monumental. In a case this explosive, a divided court, say a 5-4 decision, would have completely eroded the judgment's authority. It would have been a legal victory, but a moral failure.
It would have invited more resistance.
Exactly. Unanimity signaled that the Supreme Court, as an institution, was fundamentally united against institutionalized racism. It gave the judgment the moral and legal weight it needed to confront the entrenched system of segregation.
And the core judicial finding is so elegant in its simplicity, but just devastating in its implications for the old order.
It is.
The court declared separate educational facilities are inherently unequal.
That one phrase, it just demolished the entire legal foundation of Plessy v. Ferguson.
Yeah.
The doctrine of stare decisis, adhering to precedent, was explicitly overturned.
Why?
Because the court finally recognized that the prior precedent was morally and factually flawed. The law, in that 1954 ruling, acknowledged that separation, by its very nature, stigmatizes and discriminates. It affirmed that the state cannot legally sanction humiliation.
And the significance, of course, is that it wasn't just a win for education.
No, it became the cornerstone of all civil rights jurisprudence to follow. It decisively ended de jure by law, racial segregation enforced by state action.
So if we connect this all the way back to our 7th century starting point.
The fundamental principle is constant. It's the same principle.
Yeah.
The tribal system discriminated against the weak based on lineage and status.
Right.
The Jim Crow system discriminated against the weak based on color. In both cases, the legal system eventually had to enforce the ethical demand for impartiality.
The law had to choose.
It had to choose between power and prejudice on one side and the principle of equality on the other. And in 1954, it finally chose the principle.
So we've successfully tracked this principle's confrontation with tribe and lineage, and then with color and racial status.
Right.
But there is one final and perhaps the most frightening form of inequality that attempts to place itself above the law.
And that is the brute force of unchecked political and military power.
This is where the principle of equality faces its most extreme test.
I think so. It's one thing to challenge a social custom or even a bad law. It's another thing entirely to challenge a general with tanks on the streets.
So here's where it gets, as the research says, really interesting. We shift our focus again, this time to South Asia, specifically to Pakistan and the 1972 case of Asma Jillani v. Government of Punjab.
This case occurred during what the research identifies as Pakistan's darkest legal hour.
Why so dark?
It followed a period of intense military administration under General Yahya Khan. The general had usurped the civilian government, He'd suspended the Constitution, and he'd declared martial law across the entire country.
Which creates an existential crisis for the rule of law.
An absolute crisis.
Huh.
Martial law, by its very definition, asserts that military necessity supersedes civil law. The gun is more powerful than the book.
And historically, what had courts done in that situation?
Well, often in Commonwealth countries, and especially in South Asia, courts had applied something called the doctrine of necessity.
Which is what, exactly?
It's essentially a legal workaround. It retroactively rubber stamps a coup if it seems to have maintained order and prevented chaos.
So it legitimizes the illegal act after the fact.
Precisely. And the courts were being asked to do this again. The choice was either legitimize the coup or risk a direct head-on confrontation with the entire military establishment.
So the question posed to the judiciary was brutally simple.
Incredibly simple. Was General Yahya Khan a sovereign ruler whose actions, however forceful, were legally binding? Or was he merely a criminal trespasser on the Constitution?
Wow.
This is the moment where the judiciary has to transform into the ultimate guardian of the Constitution. It's their defining test. And the key figure here was Chief Justice Hamidur Rahman.
And his court had to articulate a principle of constitutional supremacy so robust that it could resist the pressure of the bayonet.
The political pressure must have been paralyzing. I mean, just imagine. The court had to rule on the legitimacy of the very body that controlled all the physical power of the state.
So the decision couldn't be subtle, it couldn't be nuanced.
No, it had to be an uncompromising declaration of legal authority over temporal force. And the court delivered. It defined its position in history with extraordinary, breathtaking clarity.
The source we have highlights the bold declaration made by the court. It became a watershed moment.
What do they say?
General Yahya Khan was a usurper, and his martial law illegal and void ab initio.
Okay, let's unpack void ab initio for a moment. That's not just legal jargon. It's a critical technical detail that really embodies the court's courage.
Explain it for us.
It doesn't just mean his rule was illegal going forward from the date of the judgment.
No.
It means it was invalid from the very beginning, from the moment he seized power. Legally speaking, General Yahya Khan never existed as a legitimate ruler.
So every order he signed,
No.
every appointment he made,
Boy.
every law he enforced during his entire rule was retroactively,
Oh.
legally null and void.
Yes.
That's not just a rejection of power. That's an attempt to erase the usurpation entirely from the legal history of the state.
It is a legal reset button. And this holding, it established a vital precedent. No man, no general, no matter how much force he commands, stands above the Constitution.
The Constitution is supreme.
The Constitution and the rule of law that flows from it is the only source of legitimate power. If you seize power outside of that document, you are not a ruler, you are a criminal.
And the research really emphasizes the significance of this decision, particularly in the context of South Asia.
It was a first.
The first time it says that a court in the region had asserted this fundamental level of constitutional supremacy against a military ruler. It effectively drew a bright, non-negotiable line that the military could not legally cross.
And this connects so beautifully back to the 7th century principle. It's the same thread.
How so?
Whether the court is facing the overwhelming social pressure of the Makhzum tribe in Makkah, or the institutionalized bureaucracy of racial segregation in America, or the absolute military power of a general in Pakistan, the ethical demand remains identical.
The law must be applied equally and legitimately.
And the source of power must be accountable to a higher truth, whether you call that truth God or justice or the Constitution.
So we have now spanned continents and centuries. We've looked at 3 radically different legal environments.
We have a foundational ethical ruling, a constitutional review of racial discrimination, and a defense of the constitutional order against a military coup.
It is time for our synthesis. We need to identify the deep, unifying logic that binds all 3 of these decisions together.
And the continuity is startling when you lay them side by side. It really shows that the human ethical impulse toward fairness is deeply enduring, even if the method of enforcement changes dramatically.
Let's do that. In 7th century Makkah, the enforcement mechanism was an ethical injunction from the highest authority.
Right.
Even if Fatima, my daughter, stole, she would face justice. And the principle was musawat, equality before the law, without distinction of lineage or status.
Then you jump to 20th century constitutional America. The Declaration is framed in terms of state action and rights. Separate educational facilities are inherently unequal.
And the principle asserted there was non-discrimination based on the 14th Amendment.
And finally, in 1972, Pakistan, the defense mechanism was asserting constitutional integrity. General Yahya Khan was a usurper, and his martial law illegal and void ab initio.
Upholding the constitutional equality codified under their Article 25.
So you see, the language changes. It goes from a religious command to a codified constitutional right to a defense of the document itself. But the core demand,
It remains identical.
absolutely identical. The legal system cannot differentiate between persons based on tribe, color, or the seizure of power.
This is where we have to home in on the ratio decidendi, the fundamental unifying logic. And the research we have gives us that common ethical threat explicitly.
What is it?
Law loses its soul when it bends for the powerful or discriminates against the weak.
That concept, the soul of the law,
Yeah.
it's not just poetic. It's not academic. It speaks to the very purpose of justice.
What is that purpose then, based on these examples?
Based on these examples, the soul of the law is its absolute, unwavering refusal to compromise truth and impartiality for temporary expediency or for status.
So the moment the justice system makes an exception for the person,
Be it the noblewoman, the white student body, or the military general.
it sacrifices its moral legitimacy.
Instantly, it becomes merely a tool for enforcing the prevailing hierarchy of power. It ceases to be law and just becomes power.
But let me introduce a point of friction here, because it's easy to look back and celebrate these moral victories. But how did that 7th century ethical injunction manage to survive for 1,400 years and actually influence modern secular law? Historically, didn't power usually find a way around these kinds of rulings?
That is the right question to ask. And the source material argues that the reason for its survival is that this principle was immediately deemed transcendental.
What do you mean by that?
It wasn't presented as a law invented by man for political convenience. It was posited as a divine requirement for societal order, the principle of adl, of justice.
So that distinction is critical.
It's everything, because it gives the principle a moral gravity that allows it to survive political upheaval. It isn't tied to any one ruler or government. It stands above them.
So, in the Islamic legal tradition, the concept of adl became a kind of fixed star, a non-negotiable concept against which all man-made rules had to be measured.
Exactly. And modern constitutional frameworks, though they're secular, achieve the same effect through mechanisms like judicial review and entrenched fundamental rights.
I see the parallel.
By making equality a fundamental constitutional right, it becomes extremely difficult, though not impossible, as Plessy proved, for a time for the legislature or the executive to legally violate it.
So Brown v. Board was the court asserting its constitutional review power.
To strike down laws that were inherently unjust, they were echoing the ultimate moral critique that was delivered in Makkah all those centuries earlier.
And what's remarkable here is the research's argument about the historical echo and its universal reach. It suggests that this foundational principle of non-discrimination, introduced in the 7th century, has been consistently rediscovered and codified by modern global frameworks.
This connection is absolutely crucial for understanding human rights today. The research explicitly draws a line from the principles of Adl and Musawat all the way to the Universal Declaration of Human Rights from 1948.
Which opens by affirming
The equal and inalienable rights of all members of the human family. And similarly, Pakistan's Article 25, which we mentioned, explicitly states that all citizens are equal before law and are entitled to equal protection of law.
the language is updated. It goes from an ethical injunction to a constitutional right.
But the vision remains the same, that dignity and equality are inherent. They aren't granted by the state, and they certainly are not conditional on your status, your race, or your power.
And this timeless vision requires a vigilant judiciary.
Always. The decisions we reviewed weren't accidental. They were the result of judges, whether it was the Prophet Aki, Chief Justice Warren, or Chief Justice Rahman, who demonstrated the ethical fortitude to stand against powerful pressure groups.
And affirm that power in any form.
Is inherently conditional and subject to justice.
This deep dive has spanned 3 monumental confrontations. The confrontation with tribe, the confrontation with race, and the confrontation with absolute military power. What we have ultimately witnessed is the consistent, repeated affirmation of one simple yet incredibly radical idea. The law must not discriminate based on the identity of the person standing before it.
And that means the principle of equality before law is therefore not just some legal concept designed to manage society. It is the moral foundation of civilization itself. It transcends time and geography.
It's the necessary prerequisite for stability.
It has to be. Because without it, the system cannot generate the consent of the governed. It can only rule by force.
The ultimate moral conclusion, which is so beautifully synthesized in our sources, is that the noblest law is not merely one written on paper.
No.
It's one that treats the ruler and the ruled, the noble and the poor, the majority and the minority, as absolutely equal before a higher standard of truth.
And it forces us, I think, to appreciate that law is not inert. It's not a self-enforcing machine. It requires constant defense.
From whom?
Well, the greatest threats to equality, as we've seen in all three examples, they don't come from external invaders. They come from an internal willingness, our own willingness, to let the law bend for the powerful.
Or to just turn a blind eye to discrimination against the weak when it's politically convenient.
Exactly.
And that leads us to the final provocative thought we want to leave you with, based on these powerful historical examples of courage and consequence.
Okay.
We've established the essential role the judiciary played in protecting the dignity of the weak against the demands of the strong in these three specific historical contexts. Now, look at the world today. What stands out to you as the biggest, most entrenched challenge to that very principle of non-discrimination and equality in your own society? Is it still tribe, color, or power, or is it something entirely new?